is glad to be here, that be able to actually provide an opening speech. So a little bit about us, Wawasan Open University. We are operating on 3 different pillars that we have: continual and core education, pillar number 1. Number 2 is like we are looking at our community as well as our industry. And then we also work together to make sure that we have a progress in the area of culture with diversity and creativity over here. So a little bit about open concept when it comes to learning over here. We have multiple points of entry, and traditional APEL-A, APEL-M, flexible, where you can enjoy accelerated learning journey, micro-credentials, and APEL-C. And distributed over here. What we meant by distributed is what we are doing right now, where we are scattered at different places, but we can have a same learning experience over here. So I look forward to everyone engaging with our associate professor, Dr. Bala, over here. And he's definitely very experienced. And I'm sure that please ask questions. I'm sure that, ask questions. That is the key to learning. So welcome again, and I wanted to thank you, all my colleagues at our regional center at Kuching, for putting this together. And I look forward most likely that, within the next 2 months, to visit our Kuching campus as well, so that, please come and engage with us and see that, what are the areas that we can collaborate together. With that said, thank you very much. And I'll pass this back to Mr. Jimmy Chai.
We express our sincere thanks to Dr. Gary for the highly motivational speech, and the university's doors are always open to encourage a close partnership with the industries. Now, once again, thank you for joining us today. Without further delay, let's dive into the invaluable insight that await us in these webinars. I now pass the screen to Associate Professor Dr. Bala. Dr. Bala, the floor is yours.
All right. Thank you, Mr. Jimmy, the Director of Kuching Regional Center, and also to Associate Professor Dr. Gary Tan for the introduction. My name is Bala Krishnan Muniappan. Well, you can just call me Bala. Okay, now I'll be speaking to you about one of the important topic in Sarawak, that is the Sarawak Labour Ordinance. Before I speak about Sarawak Labour Ordinance, let me give you a brief information about myself and also my experience in Sarawak. I have worked with the 2 Australian branch campus universities in Sarawak, in Miri with Curtin University of Technology, and in Kuching with Swinburne University of Technology from the year 2003 to 2015, almost close to 11 years. And I've also been an adjunct faculty member for UNIMAS, teaching courses in HR and employment law. Before I continue, I would like to request the participants to mute their audio. Only when you want to speak, when you want to interact with me, you can on your video or on your audio, and even video if you want to. All right, thank you. Thank you so much. Thank you to all the participants who are attending this session. We had about 200 over participants who registered. So far, we have about 156. So let me go into the subject area, the topic, the session, by giving you an outcome. Outcome in this of the session is that upon completion of this session, what are some of the things that all of you should know, should be familiar? Okay, number one, the first one is that upon completion of this session, you must be able to get enough information that can help you in your organization to create and sustain harmonious industrial relations or employment relation. Okay, industrial relation is a very interesting and a dynamic field of study in HR. Okay, and in organizations today, we also use a term called employee relations or employment relations. Okay, now there are a lot of distinction that you can draw between what is industrial relations and employment relations. If you go and do some search in the literature, definitely you will get more information about this. Okay, second one is to give you a basic understanding of SLO. You might be in HR or you might not be in HR, but whether you're in HR or not in HR, directly or indirectly, you will be managing people. There is a common saying, ladies and gentlemen, that not every manager is a human resource manager, but every manager manages human resources. The same is also applicable in industrial relations. Not every manager is an industrial relations manager, but every manager manages industrial relations or employee relation. Okay, so you need to know, when you are dealing with HR, when you deal with people, you need to know the legal environment, the legal framework, the laws that affects and regulates the employment within Malaysia and specifically, let's say Sarawak, specific to Sarawak. Okay, and number three is that upon completion of this session, which will take about 1 hour, I can go beyond 1 hour. There's no problem. If you have questions, you can always ask. There are not, even if I am not able to answer, there are also expertise within this session who will be able to guide you too. Okay, so should be able to learn the tools to handle disciplinary problem of employees, including termination with minimum risk. A lot of issues related to industrial relations or employment relation comes during the time of termination, and then the cases goes to the industrial relations department, to the industrial court, and also to the higher courts. So we want to make sure that you learn the tools, basic tools. Although this 1 hour session, I will not be going through the entire labor ordinance. I have a copy. Every HR people must have a copy of a labor ordinance. You need to have a copy of a labor ordinance for your reference. Okay, now coming to Sarawak Labour Ordinance, there are a lot of laws that affects employment in Malaysia. Okay, in Sarawak and Sabah, you have separate ordinance apart from the other laws like the Industrial Relations Act, Trade Unions Act, and minimum wages order, and then you have minimum retirement act, and many other acts that are also applicable. But the principal legislation in Sarawak that regulates employment law is the Sarawak Labour Ordinance. And Sarawak Labour Ordinance that has yet to be amended. Later, I'm going to talk to you about something about the amendment to the Sarawak Labour Ordinance that likely to come into force. But at this moment, at the time that I'm talking to you, there is no amendment yet. And SLO applies to employees whose monthly salary of 2,500 and below, plus other categories. Now, what are other categories? It is there in the ordinance itself. Now, for those who are earning more than 2,500, it will be dependent on their terms and conditions of employment. And most of the time, this is based on the common law principles. It has to be based on the terms and conditions of employment, but mostly the terms and conditions of employment, the minimum as per the labor ordinance is taken as a standard. Now, what is the updates? Many of you might be attending this, who are attending this session might be thinking, is there any update to the law for the what they call the labor ordinance in Sarawak? Let me tell you, so far, this is in September. This was in September. The Deputy Minister mentioned that the provisions of the labor ordinance, amendment of the labor ordinance will be incorporating some of the recent amendment made to the Employment Act. So you need to understand, Sarawak Labour Ordinance is applicable for employees who are working in Sarawak. Sarawak only. There might be companies from Peninsula or West Malaysia operating in Sarawak. I know of companies that they have already extended the provision of Employment Act, some similar to Employment Act to their employees in Sarawak and also in Sabah. Both Sarawak and Sabah Labour Ordinance have yet to go through amendment yet, but we hope that it will be on par with the Employment Act soon. Now, today, the most recent, this was shared to me by one of the member in one of the Facebook group, that is Mr. Ganesh. I think Mr. Ganesh is also here. The most recent information that we hear today was posted in the Borneo Post, okay, whereby the what they call Mr. Andrew Low, the Labor Law Reform Coalition, hits out, and he said that it's unacceptable to delay. So delay the amendment to the Sabah Labour Ordinance. So we are not going to go into all these matters, but we hope, I'm positive it will be extended. But when it is going to be extended, we do not know yet at this moment. Just wait for the announcement. All right, now, let me start with the overview. Laws of employment laws in Malaysia. There are, ladies and gentlemen, there are many laws that affects employment in Malaysia. Somebody need to mute their audio. Thank you. There are laws. Employment Act 1955, amended recently, 2022. Now, Employment Act is only applicable to Peninsular Malaysia and Federal Territory Labuan. Labuan, let's say, you might think Labuan is the other side. No, Labuan is also part of, is a federal territory. It's applicable to Peninsular Malaysia and Federal Territory Labuan. Similar to Sarawak Labour Ordinance, in the state of Sabah, you also have a Sabah Labour Ordinance. And next week on the 8th of December, I will be speaking also on Sabah Labour Ordinance. Both Sabah Labour Ordinance, Sarawak Labour Ordinance, the last amendment was 2005. At that time, I can remember very clearly, I was in Sarawak at that time in Miri. Okay, so Sarawak Labour Ordinance. And then there are other laws. Now, what are the other laws? You have laws like minimum wages order, minimum retirement age, EPF. You have Trade Unions Act 1955, which recently have been passed. The bill has been passed in Dewan Rakyat on the 5th of October 2023. And for those people who are familiar, who are in a unionized organization, now let me tell you, number or even percentage of employees in Malaysia who belongs to a union is very, very small. I can say it is about 8%, less than 10% of employees belong to a union. So there are some amendments made on the Trade Unions Act 1955. In fact, Trade Unions Act 1955 have to be amended. I always feel that it has to be amended. Many things we are not, what we call, we tend to ignore. Although the right to unionize is there, even in the Sarawak Labour Ordinance, Employment Act, Sabah Labour Ordinance, clearly stipulated the terms and conditions. Employment contract cannot have any clause that is going to prevent an employee from what they call forming or joining an association like a union. Okay, that's a separate area, Trade Unions Act. Now, Industrial Relations Act is also very important for you to understand Industrial Relations Act along with the Sarawak Labour Ordinance, because when there are termination, dismissal, okay, within the labor law, we can make, we have a lot of ways that we can differentiate what is termination, what is dismissal. Okay, there are differences. Okay, when the employee has been dismissed, what happened is that that employee who has been dismissed, can file unfair dismissal claim in the Industrial Relations Department under Section 20. So Section 20 related to unfair dismissal. Industrial Relations Act is also applicable to every what they call workman. I use the term workman when I talk to you about Industrial Relations Act and Trade Unions Act. Based on definition now in Peninsula, there's no difference at all, but still there are differences when we are looking into Sarawak and Sabah. Then there are other laws, SOCSO, OSHA, and so on. Now, for you, ladies and gentlemen, who are in the field of human resource management and in the field of management, it's
on the webinar. Saya ada webinar petang ni.
Please mute your audio. All right, thank you. So, every one of you are in the field of HR management. I would let me tell you that not only in HR, any fields, it is very, very crucial for you to always update yourself with what is happening. It's not only for people in HR, as I said to you, all managers, all employees. need to update themselves. We are actually in the world today. World is changing. Not the world today. We talk about VUCA world, the world that is volatile, the world that is uncertain, complex, ambiguous. There are even in a workforce also you can find that there are 5 generations today in a workforce. No, this is also another interesting area for us to explore. Needs and wants of the generations are also different. Workforce is changing, not like the traditional. I'm not talking about the traditional workforce in the past, but workforce today is also going through changes. How the work is going to be in the future, there are a lot of prediction by many scholars or even researchers who have mentioned about it. Okay, now let's move on into the labor. Now, some of you might be wondering why in Malaysia, the same country in Malaysia, we have a separate legislation. Why Peninsula separate laws? Why in Sarawak separate law? And why in Sabah separate law? I can go on with discussing about this. This will take you into history. Take you into history of formation of Malaysia Agreement, and many things. You have to remember that in the state of Sarawak and Sabah, anyone who goes to Sarawak and Sabah will know that it's not just you can enter any other parts of Malaysia without what they call going through the immigration. In Sarawak and Sabah, you have to go through the immigration. Okay, that means that they are separate region. It's not called state anymore. It is called region. And based on the agreement, Malaysian agreement, they do have a control to the immigration. Even when I worked in Sarawak for almost about 12 years, sorry, not 12, close to 11 years, I have to, my working permit always, the company used to renew 5 years, 3 years, around that, they used to continuously, they used to be renewed. Okay, so we are not going to go into why it is separate. If you want to know more, you do some research about why the legal environment, the laws, why separate ordinance for Sarawak, Sabah. Definitely, if you do a search, you can find ample information. Let's move into the laws. The laws provide protection for employees in Malaysia. Protection. Now, another important thing to everyone here, foreign employees. Foreigners who are working in Malaysia are also protected by the Malaysian laws. If they are working in Semenanjung, if they are working in Peninsula Malaysia, Employment Act protects them. If they are working in Sarawak, they are also within the scope of the Sarawak Labour Ordinance, same also in Sabah. Okay, remember I mentioned to you earlier, Employment Act only applicable to Peninsula and Federal Territory Labuan, whereas Sabah and Sarawak Labour Ordinance covers employees in Sabah and Sarawak respectively. Now, these laws, the purpose is to provide minimum standards for employees and to seek to protect them from exploitation. This is also on par with the International Labour Organization, that is the ILO. Now, the employment laws, what are some of the main areas it covers? Employment Act, and also to labor, the spelling here should be O added here. Automatically it moves into American spelling at times. Okay, contract of service, payment of wages, employment of women, working hours, holidays, and many other administrative related aspects. Our focus in this webinar, which is going to be about within 1 hour, more on the area related to contract of service. I'm going to, although I will go in later about the contract of service related matters, mostly related to the application of the contract of service, issues related to termination and so on. Let me give you a brief overview. Employment, as far as the employee who are covered by the Sarawak Labour Ordinance, these are some of the minimum. The ordinance itself says if you want to give more than a minimum, you are always welcome. You can give more, but it should not be less than the minimum. At this moment, okay, maternity leave in Sarawak Labour Ordinance and Sabah Labour Ordinance still 60. Although I mentioned earlier, there are companies who from West Malaysia who are operating in Sarawak and Sabah. In order to standardize, they have also implemented in Sarawak and Sabah, which is more than the existing law or the ordinance. So it's of 60. But one of the things I want to tell you is that in Sarawak, as far as the paid public holiday is concerned, you have the most in Malaysia. Okay, in the India Employment Act, it is 11. Of the 11, 5 are gazetted. The gazetted 5 are the labor law, the Labor Day, birthday of the king, birthday of the state ruler, Merdeka Day, and also Malaysia Day. Malaysia Day was included later. Okay, I can go on why it was included and all that, but for this session, just know that these are later that has been added. And then there are also other benefits, minimum, paid annual leave, minimum. It's the same as in the Employment Act, and it is also same as in the Sarawak Labour Ordinance. For employee work less than 2 years, 8 days, 2 to 5 years, 12 days, more than 5 years, 16 days. Whereas when you are looking, when you go into the sick leave, less than 2 years, minimum 14, 2 to 5 years, minimum 18, more than 5 years, minimum 22, includes hospitalization, total is 60. Okay, total is 60, including hospitalization. But let me tell you, in the amended version of the Employment Act, the 60 days is excluding. That means for employee who have worked more than 5 years, including hospitalization, you will be entitled to 82 days. Those who have worked more than 2 years, less than 5 years, maximum will be 78, and those who have worked less than 2 years, maximum including hospitalizations can be 74 days. That when amended Sarawak Labour Ordinance that will be on par with the Employment Act amends, then you might most likely get the similar benefits. Okay, now let us go into application. I'm not, as I said to you from the beginning, I'm not going to go into the section by all the sections. There are many there are some sections you don't find in the Employment Act, but there are in the what they call in the Sarawak Labour Ordinance and also in Sabah Labour Ordinance. We are not going to go into all those details. I have done many Sarawak Labour Ordinance sessions and all training, and also Sabah Labour Ordinance. Those who attend training, they will get in depth into that. But I'm going to go into section 14 and section 14A of the SLO. Now, what are section 14 and section 14A of the SLO? To those of you who have the copy of the SLO, you'll know that section 14 is about for termination for special reason. In fact, starting from section 12 onwards, it talks about termination, many things related to termination. Now, the same section is also in the Employment Act, and it is also in the Sabah Labour Ordinance. For example, the same section 14 is also in your Employment Act. Employment Act section 14.1 and section 14.2. Section 14.1 in the Employment Act talks about the employee on grounds of misconduct of the employee inconsistent with the express or implied terms and conditions of employment after due inquiry may dismiss, downgrade, or impose any lesser punishment. It's there in the Employment Act. The same also there in the Sarawak Labour Ordinance. But section 15, for example, section 15, you have a breach of contract, like section 15.2. Employee is deemed to have broken the contract of service with the employer if he is absent for more than 2 consecutive working days without informing or attempting to inform his employer of it. These are there. It's the same. But the only thing is that in the Labour Ordinance of Sarawak, it falls under section 14A. In the Employment Act, it is under section 15. Whereas if some of you are from Sabah, it's a different section. It's actually falls under section 13 and section 13A. What is section 14 in the Employment Act and the Sarawak Labour Ordinance is section 13 in the Sabah Labour Ordinance. And what is section 15 in the Employment Act? It is section 14A in the Sarawak Labour Ordinance and section 13A in the Sabah Labour Ordinance. Now, why I'm focusing on section 14? Because most of the issues or problems that employers face are related to this particular section. Because this particular section talks about termination, deals with the issues related to terminations of employment. Because many times employment termination done when an employer terminates the employee, and that termination, if it is not done in a proper way, ends up in the Industrial Relations Department or Industrial Court. And as a result, ladies and gentlemen, you know what happens is that company have to pay a lot of money, compensation. Some of the compensation, if I'm going to look into statistics, I think the last year, 1 year, just 1 year, the total amount of compensation can go into millions. In 1 year itself can be even more. I can say about, it can go into millions if you calculate. If you go to the Industrial Court website, go and check the number of awards in one particular year. Too many awards, too many cases. Even at the time that I'm speaking to you, there might be somebody who might be filing under Section 20 for unfair dismissal in the Industrial Relations Department. You can find so many cases here. Industrial Court award manager for unfair dismissal. Former manager awarded 800 by the Industrial Court. Industrial Court awarded 1.8. Recently, I came across about 2 million or so. There are people who have been dismissed. Even in Sarawak, if you look into, there is a case in 2017, Murphy Oil. Murphy Oil, one of the employees was awarded 540. Why? Because many times when the disciplinary process takes place, if an employee commits a misconduct, they want to take a shortcut. They simply terminate without going through the required procedure. What are the required procedure, which I can go through with you later. So important, why I have taken this particular section is that it relates to the many of the issues that the employers face in the organization. So what is Section 14? Section 14, as I said to you, same as what you get in your what they call Employment Act in Peninsula and also in Labuan. Is also the same. Employer, the Section 14 says that an employer may, on grounds of misconduct inconsistent with the fulfillment of the express. Express means written. Implied means not written. It can be psychological contract, implied. Okay, of his service after due inquiry. Okay, dismiss without notice, downgrade, or number 3, C is that impose any lesser punishment as he deems and fits. All right, now before I go further, okay, I want to interact with you. Okay, possibility, if possible, there are about 168 of you. How many of you have experienced terminating employees, and that termination, the employee not happy with the termination, and he took the termination to the Industrial Relations Department? And anybody want to interact? Anybody? Okay, I'll stop share for a moment. Okay, there are 168 of you here. Anybody want to share? Or you can even type in the chat. I know in webinars, usually people don't show their face. They will always, even if they want to ask something, they will put it in a chat. Any one of you want to interact? Feel free. I can give maybe 2 or 3 minutes for you to interact. Any experience? They can be.
Hi, Mr.
Yes.
Bala.
Hi.
Ganesh here. We chatted a few moments earlier.
Yes, Mr. Ganesh.
Okay. I'm a retired ERIR person, but my job all the years, I think a good 20 odd years has been in this field, and terminating employee or dismissing employee was my so-called bread and butter. So I agree with you that if you don't do it correctly, then it's going to be a nightmare, not only for you, but not only for the person who's handling the dismissal, but also the company and the bad publicity that comes along with such actions. So it's always good that you follow the procedure. And the procedure can, although the Employment Act and all that, says due inquiry and all that, but the due inquiry is a big chunk of thing, and in a big organization, that due inquiry can get very complicated and also cumbersome. So you have to do it very carefully.
All right, thank you so much for your interaction, for your participation, Mr. Ganesh. So termination for special reasons, you have you also have let's say an employee commits a misconduct, for purpose of investigation of the misconduct, the company may suspend an employee up to 2 weeks with half pay. I'm not going to go through these parts all about related to suspension due to the time factor. And there is also another part in the section 14 that says that the employee may terminate his contract of service with his employer without notice where he or his dependent are immediately threatened by danger to the person by violence or disease, such employee did not by his contract of service undertake to run. Okay, indirectly at times, this section 14 subsection 3 indirectly takes us to another field of in the employment law related to dismissal that is called constructive dismissal. But constructive dismissal is not a topic that I'm going to go through. Maybe if you are interested, if we have time, maybe in future webinar I can take it up. Related to constructive dismissal. In fact, I have written about constructive dismissal long ago, many years ago. I think the article might be available online. If you search it under my name, you should be able to find an article on the doctrine of constructive dismissal in Malaysian industrial relations. But a lot of new developments have taken place in the constructive dismissal related cases, many updates, so many industrial court awards also related to that. Now, let me go a bit on humanistic side of industrial relations. See, industrial relations, employment relations, you need to know that it's not all about law, and application of the law. You have to remember that the law is not a substitute for good human resource management. Or rather, I would call law is not a substitute for human resource management. Because when you are dealing with people, you're not dealing with machines. I'm sure you have come across this person, Dale Carnegie. He has written books, How to Win Friends and Influence People. You know what Dale Carnegie mentioned? Dale Carnegie mentioned that when you deal with people, you have to remember that you are not dealing with creatures of logic. So you have to give them all the logical sequence, rules, regulation. It will not affect them. You have to remember they are creatures of emotion. The manager at times need to understand, learn how to manage emotion. Emotional intelligence is one of the crucial, very essential and crucial competency that every manager needs to develop. And it can be developed by practice. Okay, emotional intelligence. We have rational mind, we have emotional mind. As I say, I don't want to go in depth on this part. Sorry, rational mind and emotional mind, but you can do some search about what to understand the meaning of it. Now, sorry, this is the statistics. I do not have the latest statistics because when I went into the industrial court website to look for, these are the latest one given up to 2019. 2020, 2021, 22, maybe 2023. I'm still waiting because I'm also writing a book chapter where I want to incorporate the most recent. Anybody from the industrial relations department or people in the labor government, you can, if you are here, you can tell your people there to update to the most recent. But even if you are looking into updates now, even let's say for 2020, 2020 up to 2023, I can tell you that the cases related to retrenchment, apart from misconduct is always the highest. Because misconduct, management of the misconduct, dealing with the misconduct, it still falls under the section 14. Retrenchment and all, we can take it separately. But during the COVID time, retrenchment number was higher. Retrenchment, in fact, it was higher in even in 2019. Another one that is growing is also constructive dismissal. Also, frustration of contract. Frustration of contract is another area within the employment law. When it happens when either party in the employment relationship unable to fulfill the need of the contract. One example is that prolonged illness, due to medical reasons, employee unable to fulfill the need of the contract. Even let's say the employee's professional license has been revoked. Let's say if the government orders closure of the factory, many reasons can be constructed dismissal. Also, poor performance or unsatisfactory performance. This is also another important topic, interesting topic. If there are people who are interested, we can take it up in the next area. Even any one of the topics, if there are interest, we can do a webinar. Easily we can do it for 1 hour discussion on those particular areas. So what I'm telling you is that these affects employer in terms of the cost, and most of the time who are the one who is going to kena is the HR people not doing it well. Okay, that results company have to pay compensation, a lot of compensation. And let me tell you, 2020 onwards, the number might be even higher than that. So remember that the termination part, that is the quite an important part, need to be handled in a proper way. Because of all the managerial tasks, it's one of the difficult tasks. For me, based on my research, my observation, I can tell you that termination is a result of, number one, poor selection. If the selection is right from the beginning, lot of things will be right. If the selection is not right, a lot of things can go wrong. See, if you really do an analysis in your organization, ladies and gentlemen, 50 to 60% of the HR problem could have been avoided if from the beginning you have made the right selection. All right, you have to rethink about it, how to do selection. That's another area, important area to look into selection. Nowadays, lot of times I have come across, sorry. I've just recovered from a sore throat, so excuse me if my voice not that clear. Poor selection is one of the key reasons for many HR problems. Okay, it's very, very important you pay more attention, more time you spend in doing the right selection from the beginning. Second is ineffective people management. People are not given a clear performance goals. Some companies don't have a proper performance management system. Performance goals need to be aligned. Employee performance goals needs to be aligned with the department goal. The department goal needs to be aligned with the corporate goal or business goals. So performance management is also very important. So when there are poor selection, poor performance management, what happens? Selection can go wrong. The employee at the time, what will happen is that who will not fit into the job cannot fit him, or he cannot fit into the job, will be appointed, and then that's it. You get into many problems. And then termination will be very difficult at that time to termination. You need to know that we have a right to hire. Employer have every right to hire. Okay. Someone need to mute your mic. Those of you are familiar with the Industrial Relations Act, Section 13.3. Section 13.3 provides 6 rights for management: right to employ, right to assign work, right to promote, right to transfer, right to terminate, right to dismiss. Although the termination and dismissal is a right, but it is not an absolute right. Okay, so if termination unavoidable, proper planning can avoid unfair dismissal claim. That's why very, very important. Before you do anything, always remember, before you begin anything, always remember, always think, how are you going to finish it? That's why the preparation is important. Now the preparation, as I said to you, starts from the selection, not when they are with the employee. Selection, very crucial part. Before selection, recruitment. Before recruitment is what? Your HRP, human resource plan. How are you going to acquire the right number of right people for the right job at the right time, right motivation, right pay? So many rights. Although you're not able to get all the rights, at least right number of right people for the right job, right pay. Okay. So preparation. So because when you look at termination, we can divide into 2 categories. I will speak for another 10 minutes and then I will go into interaction with you. Okay, it should be okay. 2 types: voluntary, involuntary. Voluntary, employee leave. But why do employee leave? Two main reasons, push factor and a pull factor. You can't do much about the pull factor outside, but you can do a lot to retain your employee, retention of your employee, to remove some of the barriers, why they find it difficult for them to remain in the company. Why there are many push factors? What are the push factors? How are you going to eliminate the push factor? So you may reduce resignation of people, talented people from leaving the company. Second is retirement. You have now retirement age, minimum retirement age 60. That's also another area if you want to talk about retirement, related to retirement and the other things like fixed term contracts and all that. Now, the concern more is on involuntary termination. Involuntary termination initiated by employer, usually dismissal, due to misconduct, absenteeism, poor performance, and many other types. So you have what they call, for example, breach of contract is one of the area, but depending on time, whether I want to cover that, I don't think I'm going to cover the breach of contract that comes under section 14A. I'm only going to look into section 14 of the Sarawak Labour Ordinance. All these are types of termination. Remember, dismissal is just one of the termination. Dismissal can be due to misconduct, poor performance. Both you have to remember, burden of proof is very, very important. Standard of proof, burden of proof. If you go through the Industrial Court Award, you can learn a lot about it. Burden of proof and also standard of proof. Because in a dismissal case, when a company dismisses an employee, company dismissal, pemecatan, okay, the termination, we can use the term penamatan contract. Penamatan contract, kemudian pemecatan. So dalam case pemecatan, if you want to pecat or dismiss someone, you need to make sure you have convincing evidence that the employee is guilty or the workman guilty, not the workman proves himself innocent. So in a dismissal case, this case back in the year 1985, as far as I've gone through some of the Industrial Court Award, has been quoted by the Industrial Court chair, the chair of the Industrial Court, many, many times. One is on the burden of proof, the other one is on the standard of proof. So always remember, if you terminate, kalau Anda memecat, if you dismiss someone, beban pembuktian ataupun the burden of proof adalah terhadap majikan. Majikan kena buktikan pekerja itu bersalah, bukan pekerja membuktikan dia tidak bersalah. Ini Anda kena, it's not that he goes, you have to prove he's innocent. No, you have to prove the employee is guilty. That's very, very important. But let's say if you take another type of dismissal. Actually, within dismissal, you can further categorize three. I did not touch another type of dismissal, that is wrongful dismissal. You have wrongful dismissal, unfair dismissal, and constructive dismissal. So constructive dismissal is a different area. Constructive dismissal happens when the employer doesn't like the workman. Want to remove the workman out of the company. But the employer do not want to terminate, because if the employer terminates, then he has to prove the reason for the termination. So what the employer will do? Employer will make difficult for the employee to work. Every day, humiliate him. Every day, try to find fault, giving unattainable goals, reduction in some of the benefits, a fundamental breach. The breach must be fundamental. Contract test is to be applied. Fundamental breach of contract. Then, in that particular case, employee can resign and claim constructive dismissal, can file representation under Section 20. But burden of proof will be on the employee to prove the employer is guilty, not the employee prove himself innocent. That's another area, constructive dismissal. Okay, maybe some other time, if you want to talk about it, want me to do a webinar, we can do it. So, Section 20, why? Because there is a law. You have to know that Sarawak Labour Ordinance, together with the Industrial Relations Act, you need to go through. Issues related to labor ordinance like payment of wages, OT related matters, some of the things which are non-dismissal, even dismissal, employee can even go to JTK, Jabatan Tenaga Kerja, Labor Department. They can even file at the Labor Department. But most of the unfair dismissal, they will go to Industrial Relations Department for reinstatement. The industrial court can reinstate or provide compensation in lieu of reinstatement as well as the back wages. The back wages, when you say the maximum can go up to only 24 months. So this is a section you must also understand. This is a section that will tell you that you cannot simply terminate or dismiss an employee without reasonable reason. I'm sure if people in HR must know this. Non-HR manager also must know this. And this is the section that provides protection for employees against unfair dismissal. In fact, we're going to go into, I'm not going to go detail because of the limitation of the time, because section 14 talks about misconduct. Misconduct means any conduct not consistent with the express or implied terms and conditions of employment of the employee. You can categorize this as a major and minor. What is major and minor dependent on your company. Some misconduct that are minor in some can be major in another. And there is a three categorization of the misconduct: discipline, duty, and morality. Some of you want to learn more. There is a book, B.R. Gaye. In fact, Industrial Court also quotes from B.R. Gaye. B.R. Gaye, Misconduct in Employment. So, if you are looking at misconduct, how even misconduct have changed over the years. Last 100 years, like fighting, stealing company property, sleeping at workplace. Last 10 to 20 years. In a social media era, we are all living today in an era of social media. A lot of posting in a social media also categorized under misconduct. If the employee comments negatively about the company, about the management of the company, about the fellow employee, that tarnishes the image of the company, that's also a misconduct. There are many such cases in recent years. Those who are in the field of IR, you want to do a search. Roslan Ayub versus Park Royal, which case was awarded in the year 2020, roughly about 3 years. 2021, there was a case, Hafizul versus Malaysian Airlines. Employee posted negatively about the company in the social media. The employee given a show cause letter. After that, the domestic inquiry was found, and then he was found guilty and terminated, and industrial court upheld the termination. Even most recent, there are a group of employees created a WhatsApp group to criticize the management. When management, the employer, the owner, and they have been even taken a disciplinary action. I just read a few days back. Posting on social media, sexual harassment. This is another area. Sexual harassment now in the Employment Act is mandatory for you to have the communication. It will be coming soon in Sarawak Labour Ordinance and also the Sabah Labour Ordinance. This is also another topic to take up if there are people who are interested. So social media, a lot of people making a lot of mistakes, not to say mistake. They share false information. If you share false information, okay, posting in a social media, sharing in a social media, you can do. Anything you want to share, you can share. That's your right. But when you share something that is going to defame another individual, that is going to defame your employer, then the company can take action. That's why people ask, misconduct, is it only have to be within a company? The answer is no. Even if the misconduct committed outside working hours, if it drags the company, if it tarnishes the image of the company, yes, the company can take action. That's why, but very, very important to note, ladies and gentlemen, the burden to prove the misconduct is on the employer. In one of the very old case, this case is already 41 years old, but I still take, because this case, Raja Sayang versus National Union, the industrial court says, The court agree with the union. There is no denying right, hak majikan untuk punish, memberi hukuman, menghukum pekerja. But there is also the right of the employee not to be punished and no offense. So before the hotel can show the punishment, it must prove, kena buktikan. Tanpa bukti anda tidak boleh memberi hukuman, mengenakan hukuman. So how do you do that if a misconduct committed? Lot of things that you have to go through, have to do planning. I'm not going to go into this detail. You need to do investigation, people in human resource. You can consult your people in the HR, people in your company. After investigation, preparation of the show cause, you have to know there is a show cause, there is a charge sheet. Charge sheet, you see, the charge sheet and show cause. Very crucial, you must know, write in a proper way. Because I can share with you there are many cases companies have lost due to failure to write a proper charge sheet. Defective charge. When you write a charge sheet, you have to make sure what are the offense, when it has been committed, where it has been committed, how it relates to the company rules and policies. You cannot have a very vague charge sheet. There are a few cases I can share with you. Yahya Tala versus Petronas, back in the year 2019, 15 around, And then you have a case of Zailan Zawawi versus Harish B. There is also a case of Maimuna Ahmad versus SO Production. All these cases, company lost due to defective charge. So how you write the charge sheet, very, very important. Surat Tuduhan, charge sheet is a Surat Tuduhan. And then of course, I can go through the requirement of domestic inquiry. In the Employment Act and also the Sarawak Labour Ordinance, Section 14(1) clearly mentions the requirement of domestic inquiry. Although it is mentioned due inquiry. Okay, let's say if you don't do an inquiry, you dismiss an employee. What will be the scenario? Well, in some cases, I can tell you in most cases, the risk is high. Higher risk. We have expertise later on, maybe I can introduce him to you, who have written a book on domestic inquiry. Maybe he can share his thought. Maybe later I can give some time for him to share his thoughts. Inquiry, domestic inquiry will minimize the risk. And that inquiry needs to follow the rules of natural justice. Why we do a domestic inquiry? To allow the accused opportunity to defend against the charges leveled against him, so that a fair and impartial decision can be arrived. So as per the Labour Ordinance and also the Employment Act, before you could dismiss, downgrade or suspend an employee, you must follow a fair and proper inquiry, and the inquiry must follow principles of natural justice. Natural justice, ladies and gentlemen, is applicable in every aspect of law, including the administrative law. So there are two principles in the conduct of inquiry that you need to adhere to. Number one, audi ultram partem, hear from the other side. Before you pass a judgment, make sure you have heard from the other party. Don't hear from one side and then you give a judgment. According to Lord Dennings, in one of the classic case, he said that in this audi ultram partem means that the accused must be given sufficient opportunity to actually see, hear, and question all the witnesses one by one from whom the statement were taken. That's the first principle. Principle number two, you must make sure it must be seen to be impartial. So the term, he says, this is principle number two, nemo judax in causasa, no man shall judge for his own cause. This principle also very important, because when you select the board of inquiry, Usually the board of inquiry will have 3, maybe 4 with a secretary. 3, a chair and a panel members, 2 panel members. A chair and 2 panel members. What are the criteria to select the board of inquiry? There are many criteria. I'm not going to go into that part. Criteria to make sure, you want to make sure they are independent, they are not from the same department, higher rank than the accused. There are certain criteria. Okay, nemo judax in causasa, meaning that the people or no one who has any interest in the case must be there in the board of inquiry. So these are some of the classic, okay, almost 4. Classic, not almost 4, already 4 for 2 minutes. Classic case laws related to domestic inquiry. Even back in the year 1962, Surinder Singh Kanda versus Federation of Malaya, Privy Council, Lord Denning's judgment. Then you have also about 43 years ago. These are some of the landmark cases where the important principles of natural justice has been provided by the court, industrial court. Some even you can find it in the higher court, appeal court, or even federal courts. So disciplinary action can be dismissal, downgrading, suspension without pay, and many more. So when you implement, you have to make sure what do you call this? Hot stove rule. Disciplinary procedure must be predictable. Everyone should know. Company handbook must be clear. Policy manual must be clear. HR manual, company handbook. Predictable, immediately. You don't delay. When you touch a hot stove, immediately you're going to delay. Consistent. 1 second, burn is less. If you are holding it for too long, maybe 5 seconds, more. Impersonal. Dia tidak pilih bulu. Anybody. Even the MD, CEO. If they break the rule, will be punished. So even after dismissal, employee have the right under Section 20 of IRA to file unfair dismissal claim at the Industrial Relations Department within 60 days. So I mentioned to you earlier, this Section 20 is an important section for a workman because security, tenure of employment, even protected under federal constitution. Right of livelihood is mentioned in the federal constitution. Interpretation of Section 20 in the past, the court have also cited federal constitution and also many other cases, many other laws. So Section 20 very clearly says, well established and well known that for an employer to dismiss a workman, there must be a just cause or excuse. Just cause or excuse must be based on facts of each case, either misconduct, negligence, or poor performance. The onus is the employer to prove just cause or excuse. We are coming towards the end, 1 or 2 minutes, okay, on the practical lessons. These practical lessons you can, based on 1 hour. 1 hour I didn't talk too much. As I said, I'm recovering at the recovery stage, almost like 1 week. Should be okay in next few days. So 1 hour is mostly overview on the application, especially within Sarawak Labour Ordinance Section 14. Only Section 14 is only 1 section. In fact, even 1 section we can do a whole day of a training. That's why for all of you here, people who are in HR, let me tell you, you don't think you can be a clever if you solve problem. You have to be wise to avoid a problem. To avoid a problem that many HR goes through, going to Industrial Relations Department, going to the industrial court, documenting this, documenting that, dealing with termination, dismissal, you can avoid if you can avoid termination. That's why you have to always look into a proactive way to avoid termination. I have given you 2. Number 1, start with your selection. Right selection from the beginning. Second, performance management. Clear performance management goals so that people know clearly what they are expected to do. coaching, guidance, training, right training, not any training that are aligned to their needs, competency. That's why you need to do a proper TNA, training need analysis. Employment relation, employee engagement, many things. If you have it in practice, you don't have to go to JTK, you don't have to go to Jabatan Perhubungan Pindah Perusahaan. You can avoid everything. You can avoid all this. So in a conclusion, let me say, law is not a substitute for good HR practice. Always you practice humane management, good management, then you will be able to be a best HR manager or best manager, a great manager. You have to move from good to great. Jim Collins in his book, good to great. You're good. All of you, I can say you're good. In fact, you are attending this session to learn, shows that you are good, already good. But we have to move from good to great by practicing good HR practices. Then you will become great HR manager. And I would like to thank everybody and also thanking the organizer, that is Mr. Jimmy. Now, before that, Mr. To, you are here, right? Are you still here? I want to give you some time. He's a well-known expert, one of the leading experts in Malaysia within the area of labor law, employment law, and also industrial relations. He has recently wrote a book. I have not read his book, but I'm sure the book is a very interesting book. He wrote a book on domestic inquiry. Maybe you can take about 2 minutes or 3 minutes. You want to say something about the importance of why domestic inquiry is important, Mr. To. Over to you, Mr. To.
Yeah, thank you, Prof. Bala. Good afternoon, everyone, and thank you to Wawasan Open University for the opportunity. Yeah, maybe I'd like to share a bit about due inquiry, because just now Prof. Bala talked about due inquiry. So what is due inquiry? Remember, under Section 14 of your Sarawak Labour Ordinance, the law never say that you have to do a domestic inquiry. The Section 14 only says that you have to do due inquiry. So before you terminate anybody, please do your due inquiry, because you can be a hero in your company. I always share this in my training sessions, that you can be a hero in your company. You can say, "Sack, get lost, I don't want to see you." Yeah, you're the boss, you're the hero. But if that guy challenge you and bring the case to the industrial court, please be a hero in the industrial court. Don't go to the industrial court and be a zero there. Yeah? Then you'll be shivering in court. You'll be wondering, how are you going to explain to the industrial court that you have terminated this guy rightly? Okay. So, and as HR practitioners, please, you must also use your discretion and figure out when do you need to do a domestic inquiry. Right? So in certain circumstances, you don't have to do a domestic inquiry. Use your discretion. Now, what are those circumstances? If, let's say, in your show cause letter, the employee has pleaded guilty, right, without any threat, promise, and inducement, he has voluntarily pleaded guilty, there's no necessity for you to do a domestic inquiry. Now, that's another situation where if the employee, when you give him a show cause letter, he may have resigned, tendered his resignation, or he may have even absconded. Do you want to do a domestic inquiry? To me, not necessary. What are you going to do? What sort of domestic inquiry are you going to do? Okay? So just within this limited time, I won't want to take up a lot of your time. Yeah, so just to share with you, due inquiry, it can be anything. As long as even if you give him a show cause letter, that is part of due inquiry already. Okay? Even if you ask him, but asking him is a bit problematic because it's verbal, not documented. Even if you gather his blood samples or urine samples, you bring it for analysis, you gather CCTV recordings and all that, those are part of your investigation process. That's part of your due inquiry process. Okay, thank you, Prof. Balan. Just a little bit of sharing from me. I don't want to take up a lot of your time. Thank you for the opportunity. Bye, everyone.
Thank you, Mr. To, for your sharing. And thank you everyone for your participation. And many have that are commented. Thank you, Tony. Thank you, Ian, Laura, and thank you to Haji Mosidi. I will pass it to Mr. Jimmy. Thank you, Joanne. I'm passing it to Mr. Jimmy for the closing remarks. Thank you. to everybody.
Okay. We extend our sincere appreciation to our distinguished guest, Dr. Bala, and our special guest, Dr. Gary, for their valuable contributions today. As we conclude today's webinars, we want to emphasize our commitments at Wawasan Open Universities to fostering lifelong learning and collaboration with industry partners. And the door of our universities are always open and inviting opportunity for a closer partnership with industries. Now, for example, if after today's session, if you have any wish list, want Dr. Bala to do another webinars on HRM related topic, please let me know. In this, we have a WhatsApp group with a participant, or directly messaging me to my WhatsApp or my email. And we will try our best to discuss with Dr. Bala and to make it happen. Now, on behalf of Wawasan Open Universities, our speakers and everyone involved, thank you for your active participation and wishing you continued success in learning in your respective fields. Until we meet again, take care, stay connected. Thank you very much. Have a nice day.
Thank you, everyone. Thank you to all for your participation. Next week, I will be speaking on Sarawak Labour Ordinance. This is going to be similar, but this is for participants in Sabah. Thank you to everybody. Thank you.
Mr. Jimmy, I think Joanne says she wants to join the group.
Oh, okay.